Good morning, Canada. Alex Monahan here, Foundations Party ineligible. Today's date is April 18th, 2017, and we are going to continue reading the Canada Immigration Refugee Protections Act. And we are going to continue off at Division 10, since we left off on the second half of yesterday's video. So, let us begin. Division 10, General Provisions. Instructions on proceedings, applications, and requests. Applications. Paragraph 37.3, subparagraph 1. This section applies to applications of visas or other documents made under sections 11.1 and 1.01, other than those made by persons referred to in subsection 99.2, to sponsorship applications made under subsection 13.1, to applications for permanent resident status under subsection 2.21, subparagraph 1, or temporary resident status under subsections 22.1 made by foreign nationals in Canada. For applications for work or study permits, and to requests under subsection 25.1 made by foreign nationals outside Canada. Attainment of immigration goals. Subparagraph 2. The processing of applications and requests is to be conducted in a manner that, in the opinion of the minister, will best support the attention of the immigration goal established by the Government of Canada. Instructions. Subparagraph 3. For the purposes of subparagraph 2, the minister may give instructions that respect to the proceedings of applications and requests, including instructions. Subparagraph A. Establishing categories of applications or requests to which the instructions apply. A1. Establish conditions by categories otherwise that must be met before or during the proceedings of any applications or requests. B. Establishing any order by category or otherwise for the purposes of the applications or requests. C. Setting the number of applications or requests by category or otherwise to be proceeded in any year. And D. Providing for the disposition of the applications and requests, including those made subsequent to the first application or request. Application sub 3.1. An instruction may, if it is provided, apply in respect of pending applications or requests that are made before the day of which the instruction takes effect. Clarification, subparagraph 3.2. For greater clarifications, an instruction given under paragraph 3C may provide that the number of applications or requests by category or otherwise to be proceeded in any year be set at 0. Compliance with instructions, Subparagraph 4. Officers and persons authorized to exercise the powers of the minister under Section 25 shall comply with any instructions before proceedings and apply or request or when proceeding, before proceedings and applications or requests or when processing one. That makes a little more sense. If an application or request is not processed, it may be retained, returned, or otherwise disposed of in accordance with the instructions of the minister. Clarification. Subparagraph 5. The fact that the application or request is retained, returned, or otherwise disposed of does not constitute a decision not to issue the visa or other documents, or grant the status or exemption in relations to which the application or request is made. Publications. Paragraph 6. Instructions shall be published in the Canadian Gazette. Classifications. Subparagraph 7. Nothing in the section in any way limits the power of the minister or otherwise determine minister to otherwise determine the most efficient manner in which to administer this act. Federal skilled workers. Applications made before February 27, 2008. Paragraph 87.4. Subparagraph 1. An application by a foreign national of a permanent resident visa as a member of a prescribed class of federal skilled workers that was made before February 27, 2008 is terminated if, before March 29, 2012, it has not been established by the officer in accordance with the regulations whether the application meets the selection criteria and other requirements applications to that class. Application. Subparagraph 2. Subsection 1 does not apply to an application in respects of which a superior court has made a final determination unless the determination is made on or after March 29, 2012. Effect. The fact that the application is terminated under Section 1 does not constitute that the decision not to issue a permanent residence visa. Fees returned. Subparagraph 4. Any fees paid to the minister in respects of the application referred to in subsection 1, including for the acquisition of permanent resident status, must be returned without interest to the person who paid them. The amounts payable may be paid out of the Consolidarity Revenue Fund. No recourse or no recourse in indemnity or identity. Indemnity? Anyway. So paragraph 5, no person has the right of recourse or indemnity against Her Majesty in connections with the application that is terminated under Section 1. Federal federal investor and entrepreneur class. Pending applications. 87.5, subparagraph 1, an application by a foreign national for a permanent resident visa as a member of the permanent class of investors or of entrepreneurs is terminated but if before February 1st, 2014, it has not been established by an officer in accordance with the regulations whether the application meets the selection criteria and other requirements applicable to the class in question. Application. Subparagraph 2. Subsection 1 does not apply to A. An application in respects of which a superior court has made a final determination unless the determination is made on or after February 11th, 2014, or B. An application made by an investor or entrepreneur who is selected as such by a province whose government has entered into an agreement referred to in subsection 9.1. Effect, subparagraph 3. The fact that an application is terminated under section 1 does not constitute a decision not to issue a permanent resident visa. Fees returned. Any fees paid to the minister in request of the application referred to in subsection 1, including for the application of permanent resident status, must be returned without interest to the person who paid them. The amounts payable may not be paid, the amounts paid may be paid out of the Consolidation Revenue Fund. Investment returned. Subparagraph 5. If any application of a permanent resident visa as a member of a prescribed class of investors is terminated under subsection 1, an amount equal to the investment made by the applicant in respects of their application must be returned without interest to the applicant. The amount may be paid out of the Consolidated Revenue Fund. Oops, this thing turned off on me. Provincial allocation, subparagraph 6. If the province or provincial allocation of investment made in respects of an application for permanent residence visa as a member of the prescribed class of investors that is terminated under subsection 1 has been transferred to an has been transferred to an approved fund as defined in subsection 88.1 of the Immigration Refugee Protection Regulations. The province whose government controls the approved fund must return the amount equal to that provincial allocation to the minister without delay. The return of the amount extinguishes the debt obligation in respect of the provincial allocation. No recourse or mediation or indemnity. Subparagraph 7. No right of recourse or indemnity lies against Her Majesty in right of Canada in connection with an application that is terminated under subsection 1 including in respects of any contract or other agreements relating to any aspects of the application. All right, my friends, that'll be all for today's first half, and we will be posting the second half shortly. Thank you very much, and stay posted.